want to pick up on that question about why, and Justice Kavanaugh said, why are you afraid of a hearing, or what would there be that would be wrong with process? I mean, you spent a lot of time litigating the case. You know, it's gone up from the district court to the Court of Appeals, and now we're here. And if there isn't anything to fear from a hearing, and if you have the evidence, why couldn't those resources have been put into a hearing? I understand you think that you don't have to provide one, either because of the statute or because of the due process clause, and that's fine. But in thinking about irreparable harm to the government, if one step you could take to reduce your irreparable harm, to show that there really was cause, is just to have a hearing, why not?
I don't think it's a question of resource allocation. It's our position that adequate process was already provided. So if it's a question of the district court's ordering us to go further and then go further and go further again, all without any legal or constitutional authority in our view, we think that imposes irreparable injury on the executive.
Well, they told you to go farther, but not that much farther. I mean, okay, so there's the Truth Social post, and then, you know, burden on her to come back in 5 days. I understand that's your position. But, you know, Justice Gorsuch posited sit down across the table in the Roosevelt room, where the president provides Ms. Cook, Governor Cook, with the evidence and waits to hear what her response is, gives her a chance to defend herself. I mean, that just wouldn't be that big a deal, it seems, if that's enough.
Again, it's an intrusion on the executive branch to dictate what procedures it ought to provide.
So it's standing on principle.
The president, and our position is he has provided process. He's provided adequate process. And if the district court said, well, that wasn't quite good enough, try again, and then we try again, and the district court says, nope, that wasn't quite good enough, try again, we have gone left Vermont Yankee way in the rearview mirror.
Do you concede that if the statute was an INM statute, that under Shurtleff you would have to provide process?
Notice and hearing, yes.
Yes.
We don't dispute that.
And I want to go back to one of Justice Kagan's questions. She said, well, in Shurtleff, the statute itself didn't say that you got notice in a hearing for INM, but the court said that you did. Here, the statute does say cause. Cause isn't as specific, maybe, as INM, but it does identify the grounds that the president must have for removal. Why shouldn't we do the same thing that the Shurtleff court did and say that, well, as we said in Shurtleff, when a statute specifies the grounds for removal, there must be notice in a hearing given?
Because the case law, presumably Shurtleff, when it said that as to INM, notice you get notice in a hearing, was relying on what we don't dispute is a, as far as I can tell, pretty consistent strain in the case law that that's what that means. It gives you specified causes like that, INM, give you notice in a hearing. The case law on cause is the opposite. I mean, look at the lower court opinion in Reagan, in the Court of Claims opinion, where they say cause does not mean you get a notice in a hearing. And we cite a strong line in the background case law as well. Now, they dispute, they say there's some cases going the other way. However, the notion that they are making an old soil argument. They're saying, oh, this, in order to prevail on that, it has to be so well settled and clearly established that there really wasn't a dispute about it. And you look, I can't emphasize enough, you know, what, for example, the Tuttle Michigan Law Review article from 1905 that's heavily relied on, for example, in the Manners amicus brief that they rely heavily on in their supplemental brief. It says the case law is all over the map on all of these issues. That treatise says the courts differ on almost every conceivable part of this question. The only point of consistency is that specified cause is INM, which also, as we can see, is a holding of the court in Shurtleff. Whereas cause just doesn't mean that. And we've cited all these cases they dispute, and there's this battle about what did the 19th century case law mean. Keep in mind, in the context of that battle, they bear the burden of making the old soil argument.